Fabulous people. I am super pumped today to introduce you to a powerhouse principal lawyer who runs her own law firm in Melbourne, Jennifer Holdstock. Hi, Jennifer.
Hello. Morning, everyone.
Thank you so much for taking your time out today to do this session with us and for being a judge this year for the Raw Awards. I know you've had your work cut out for you in the category you're judging, but super appreciate your time. So I would love for you just to tell the group, for those who don't know you, I know that there's a couple in the group who have met you and utilised your amazing services, myself included. Just a little bit about who you are and what you do and where you're based.
Yeah, so my office is in Burke Street in Melbourne. I've been a lawyer for 18 years and I've worked in a combination of law firms in-house for a company and then obviously for myself. In January it will be 8 years. I've been running my own firm, which it feels a bit like I blinked and then somehow it's been 8 years. So I remember when I started out thinking, now if I can't afford to eat, I'll have to move home with mum and dad. That's like my worst case scenario. And somehow it's been 8 years and I've eaten and I haven't moved home with mum and dad and I now have 3 amazing staff. So it's incredible to believe it's been 8 years. So we do predominantly litigation, so disputes, and that's across like the workplace, field, property, contract disputes, intellectual property. That's sort of the nature of our work. I also prosecute for the Health Practitioner Regulation Agency, so like for the Medical Board or the Nurses Board or the Psychology Board. That's been something I've done for the most of my career. And I do some commercial work from time to time for existing clients. We used to do conveyancing and that sort of thing, but I think we tried to do too many things across too many areas and it wasn't good. So we focused really now on disputes, which I love, and I've got a fantastic team behind me and I'm happy to say we've had a good year, even though it's been an interesting year. But yeah, so that's what we do.
You do it very well, by the way. And congrats on 8 years. I know what you mean when you say you think, you know, you start out and you think, oh, I hope it works. I hope I can feed myself. I don't really want to go back and live with mum and dad. But can I ask you, Jen, how you got started in law? Obviously, you must have loved it when you were younger, but how you got started and how that went for you, because there's obviously a big risk to going into law, particularly as a female as well. I would imagine it's quite a heavily male dominated industry.
Yeah, it is. So there's a few things I'll say in answer to that. The first thing is the reason I became a lawyer is because when I was younger I read every John Grisham book he ever published and I wanted to do what those lawyers did in those books. And I'm proud to say I've read every one of his books, and every year when it comes out I buy it within the first few days and I've smashed it and then I give it to my brother. So that sounds cheesy and contrived, but that is the reason I wanted to become a lawyer. Also, I think I've always been argumentative. My parents would certainly say that. And so I like a battle. I like writing a nasty letter. I like sifting through evidence and finding, you know, little bits of golden nuggets. And I've done other work over the time. I've done property law, which I hate. I've done commercial law, which I hate. So you learn pretty quickly, you know, what appeals to you and what suits your personality. And I normally live a fast-paced life. And so the litigation helps because it's, you know, it's different. Every case is different and it keeps me interested. The fact that I'm still in the profession 18 years on is significant because the dropout rate for women in the first 5 years of being in law is huge. The only reason I think I've survived is because my whole career I've had mentors, and all those times when you doubt yourself or you think that law's not for me, or I can't handle it anymore, or I can't work these hours, or, you know, I'm sick of dealing with these egos, or partners in law firms who are made partners because they bring in the money but they don't have any management skills. The only reason I've survived is because I've had mentors that have guided me through, you know, all of those times. And I think whatever you do in life, you know, professionally, you should have a mentor. And then every year on the anniversary of when we started Articles, which is the 4th of March, the guy that I did Articles with, who's still at the firm where I started, he's a partner there now, we have a lunch every year on our anniversary and we ask each other the difficult question. Why are you still in the law? What are the highlights for you? What are the lowlights? Have you thought about leaving in the last 12 months? If so, why? And it's become a bit of an important tradition, I think. And so our 20 years is coming up, and I said to him, let's go to Las Vegas for our 20 years. And he was like, what? I don't know. And I was like, come on, 20 years surviving in the law is huge. So I'm really desperate that we'll get to Las Vegas, but I think COVID has probably put an end to that. So we'll have to find something equally debaucherous to celebrate 20 years. But yeah, look, it's been tough. I've worked 18-hour days at certain firms. It's pretty thankless. It is still very patriarchal. The numbers of women, both at the bar, being a barrister, and also partners in law firms, is very low relative to the number of females at law school. So at law school now, there's more women than men, but it doesn't translate into senior positions. And I think ultimately the reason I went out on my own is because if you become a partner in a law firm, you take on joint and several liability for other people. And I worked with some male partners who were a sexual harassment claim waiting to come, or just not very good lawyers, and I wasn't prepared to take on joint and several liability for them. I'm prepared to own up to my own mistakes, and I'm prepared to wear liability for my own mistakes, but not somebody else's. So I set up on my own 8 years ago, and here we are.
I hope you get to go to Vegas. I hope something happens. And
I know, why not?
They just make an exception. You've survived 20 years in law. I feel like there should be a chartered flight just for you.
Exactly. And I feel like he should have considered it more before he just turned me down flat. But I'll keep working. I've got time on my
negotiate.
Yeah, I've got time on my
Reject the first offer.
That's right. Exactly.
Do you think there's a defining moment in your career, Jennifer, that stands out to you in all the years that you've been doing what you do?
I don't think there's one. I think there's several. I've worked on several high-profile pro bono cases that have meant a lot to me personally. Like I worked on the case where the girls were banned from playing football against the boys years ago, and we took them to VCAT and got an injunction, and they were allowed to play out. And they made a movie about that case, and I was in the movie. That's a pretty interesting highlight. And now when I see like the Women's Footy League and how many women are playing footy, I find it hard to swallow, because we received so much resistance in that case. That was in 2003 and 2004, because the Football Victoria ran the line that, there's not that many women that want to play footy. And now there's a league all over the country, and every time I see a news item about it, it makes me sort of spit chips, because I'm like, we did this, we did this. But I think the true moment for me was there's a QC that I really respect called Julian Burnside, who is one of the smartest people, but also the kindest, because he does so much pro bono work. And I was working on a case with him years ago, an injunction case about a chicken farm, of all things. And I learnt stuff about chickens and the way they're raised that you can't ever forget. But in a meeting with the clients during the middle of a really fast-paced injunction, we probably worked for 5 days straight without sleep. We were in a conference with the client and the lawyers and all the barristers, and I said something, and he said, "Oh, Jennifer makes a really good point." And I was like, "Oh, like Julian Burnside knows my name," and he just thought I made a really good point. And that was, it sounds like I don't rate myself for ever making a good point. That's not what I mean, but it was truly shocking when he said that to me, and it's something that I will always remember.
That's like that rock star moment when the rock star's singing and they point out and they sing to you in the crowd and hand you the microphone. That was kind of your moment.
Yeah, and then I kind of thought, what did I say? What did I say that he thought was so good? Like, write it down. So yeah.
So with this year, I'd love to know, Jennifer, how obviously with the situation with COVID, things have changed, particularly in, I guess, no sector or no industry has been immune to this. Everybody's been affected, but you have mentioned that you've still had a great year. What do you think the biggest challenge that your industry is facing right now, and what are you sort of doing around that to, I guess, help your own firm and your own position?
It's interesting you asked that, because in 18 years of my legal career, I've seen no move in the legal industry in terms of moving with the times, and I mean none. And this year, the profession has moved at rocket speed to keep up with the demands, but also embarrassingly in terms of what it's had to do. So the Magistrates Court basically has not operated at all year, because it does not have the infrastructure to do so. And mid-year we had a mediation scheduled, and they said it was going to go off, and I said, can't we just do it via Zoom if I send everybody a link? Because I've used Zoom for years because I have American clients and clients in Singapore, and I've always used Zoom. I haven't, you know, it wasn't a new thing to me. And the court said, we can't do that. We don't have the infrastructure. And I said, no, but I can send you the Zoom link. You just need to download it. No, we don't have a protocol or a practice note for that. And I said, okay, what about phone? Like we can do, you know, we can do it by phone. And they said the magistrates court has phones that don't allow you to have more than 2 lines at the one time. And I was like, I mean, I'm a technophobe, quite frankly, and I was making suggestions to them, which is stunning, because really, my brother would say that to you, that I should never give people technology advice. But that's been shocking. VCAT basically has come to a halt as well. They've started to pick things up now because they've had a huge funding boost to pick up the infrastructure. But the federal court, conversely, has continued. They've just adapted and started using, they use Teams. And they've used that flawlessly, and the county court equally has gone on about their business flawlessly. So it's shown a real divide between who's had funding boosts in recent years and what they've done with them. But even law firms, like because I've used Zoom for years, we all came home and started working from home on about the 10th of March because I was concerned about the risk. I have, celiac disease, which is it affects immunity. So we all came home thinking, oh, we'll be home for a couple of weeks, and then, and somehow we're still at home. But my firm adapts seamlessly. We've all started using Teams. We've used Zoom. We have meetings every morning, telephone meetings with the staff walking. We've adapted to that because for people's mental health and fitness. So now we take our meetings walking, and we haven't skipped a beat, our firm, in the way we've operated. So clients have had a seamless service. Obviously, we've had lots of logistical issues. Like I needed a client to sign a document yesterday, and he said, I've got a computer, but I don't have a printer or a scanner. And I was like, oh, okay. So I posted him something in the mail, and he's going to post it back to me, and I'll probably get it next year. But we've had to adapt in that respect. But otherwise, our clients have had a seamless service because we've just adapted, to working from home. But the courts have not kept up. So I think what we've seen is a lightning speed adaptation from all those areas, courts in particular. We had mediations online. We've had mediations with the Small Business Commissioner online. I've appeared in the federal court in Sydney, in my pajamas. Don't tell anybody. And yeah, when they have adapted, it's been good. But the delay, and so the consequent delay to the court process, is most of this year's work has to play catch up, and then we have next year's work coming. So there are going to be delays in the court system for years to come because of this, because they did not have the appropriate funding and infrastructure to adapt the way that was necessary. And so litigants in particular, are going to be feeling that pain for a long time to come. A bit like the health service has let us down because it's been underfunded. The legal industry has been underfunded. The infrastructure they have at the magistrates court is embarrassing.
It's archaic they don't even almost.
Those octopus phones that they talk about. Yeah. They didn't even have those. So, anyway, they're adapting slowly. But the backlog, like I'm telling people, if we issue something in the magistrates court now, where once upon a time you would have got on before Christmas, we're now looking at the middle of next year, if not further, because they're trying to catch up the backlog as well as deal with new matters. So the delay is going to be immense.
Yeah, that's a huge knock-on effect, isn't it? From very archaic way of thinking and doing things, now it's going to, like you said, essentially. Is there anything, Jen, I guess everybody in the group, in their business, it's easy to skip over the legal side of your business and not have all your ducks in a row and have it sort of bite you on the bum, hopefully not, but sometimes later on down the track. Do you have any advice, given the state of the industry that you're in, of what businesses should be doing now or implementing now to make sure that they're covered and protected? Because you wouldn't want to end up in litigation or a court case because you may not get an outcome. And by the time you do get that outcome, it could be game over. Is there anything that they can do?
So we've definitely seen a shift in the number of people who are negotiating force majeure clauses into their contracts, which is a clause you can rely on when things outside the party's control interrupt your ability to comply with a contract. Say, for instance, a pandemic. Normally it's things like weather events and that sort of thing, war. But we've seen a shift into that. So if you're entering into new contracts, you should just make sure that that clause is negotiated in, because if for some reason you can't uphold your end of the bargain, you want to be able to rely on that. And the number of people that don't have those clauses in standard sort of supply agreements is quite surprising. Even though the pandemic has ruled out ability to claim under insurance, looking at your insurance arrangements in any event is really important. I think people have taken for granted for a long time that they have appropriate insurance cover, and then they've been caught short. I would also look at staffing arrangements under the Fair Work Act. There's so many changes that are happening there that we've almost had whiplash this year trying to keep up with it. But also, if you're running a commercial business, look at your options to get rent relief. I spoke to a chiropractor last week, and he said, "Oh, I don't qualify for rent relief." And I said, "Oh, really? Has your business suffered a downturn?" And he said, "Yes." And I said, "So why do you think you don't qualify?" And he just didn't. He hadn't even considered it. So squarely look at any rent relief you can have. But in terms of trying to avoid disputes, as a litigator, I'm doing myself out of a job by saying this, but if you get your house in order at the beginning, whether you're entering into a partnership with someone or setting up a company structure and you need a shareholders agreement or whatever, getting your IP in place, people are worried about spending money up front when they're setting up a business because it's a lot of money. And when you're starting up a business, you don't have a lot of money. But if you can spend $500 or $1,000 or $1,500 getting proper agreements done in place, then you can avoid expensive litigation down the track. And I mean, if you're dealing with someone like me, it's going to cost you way more money to litigate a dispute than it is just to pay a commercial lawyer up front to get your house in order. So, you know, I'm doing myself out of a job by saying that, but I literally mean that you can save yourself tens of thousands of dollars if you just pay to get those simple agreements done up front. And I can't emphasize that enough. The number of people that come to me and say, I've set up a company with my friend, and I say, "Oh, have you got a shareholders agreement?" And they look at me dumbstruck and they don't even know what I'm talking about. It's not funny. So really get your house in order early, and you can avoid, you know, not just in the pandemic, but in general, you can avoid a lot of pain.
And touching on that too, Jen, I think a really good one to touch on in the group is we've become this really impatient, fast-paced way of doing business. And a lot of the websites that, you know, I'm in a lot of big groups online where people constantly ask for legal advice or does someone have a template for this or someone have a template for that? So, and we've had that discussion too about utilizing just templates or, you know, different websites, won't name them, that have that just free downloadable and, you know, use this. The dangers of those and the pitfalls of those in business. I know you touched on it's way better to do it in the beginning and have those, you know, your ducks in a row and have those things covered. But what are some of the risks to using just that fast downloadable click? I'm just going to use this, you know, brand agreement or, you know, distribution agreement or service agreement.
Yeah, so I mean, in some instances, those things can be straightforward. If you need some, like a straightforward statutory declaration or like a one pager or whatever, and you can get one for free and it doesn't have any stuff in it that could date, then go your hardest. Do what you need to do. It's better to have a written agreement than have nothing. But I'll give an example. A client of mine had a privacy policy that was attached to their website that they had. They sent it to me and said, "Can you review this?" And I opened it and had a look at it and I was like, okay, where's this come from and how long have you had it? Because the legislation that you refer to was updated years ago. Like, all the language is wrong. So the problem with something like that and not reviewing it, you know, regularly, is that you have documents in place that are no longer enforceable or out of date. So I understand that legal advice upfront is expensive. I'm not, you know, I've been working in this field for a long time. I understand that, but really, what people don't seem to understand is it can cost you way more if you don't do it right. Also, shareholders agreements. I've had so many clients say to me over the years, "Oh, we just need a simple shareholders agreement," and I'm like, not really such a thing
Simple.
as a share. Yeah, exactly. Or can you just knock me up a partnership agreement? I just need it to be, we're just going to be 50-50 and that's it. Like, it's just 50-50. Can you just knock me up something? I don't want it to be
Make that happen.
Yeah, I had a client recently ask me for a straightforward sponsorship agreement. You know, I want it to be like a page or a page and a half. And I said, okay, what do you really want? Yeah. Because I can't give you one of those for a page and a half. Like, you know, I understand you want it to be straightforward and simple and basic and whatever, and that can be the case, but it can also be a legally enforceable agreement. But if it is going to be that, it's not going to be a page and a half. So people do have fixed ideas about things, and I think that, you know, it seems like you're doing the right thing to download a precedent off a website and think, well, you know, I've done the right thing, I've got this in place. And there's no reason to suggest that you can't do that and then get a lawyer to check it. It's going to be cheaper for you to get a lawyer to settle a document than draft one from scratch. So if that's what you want to do, that's fine. The problem then becomes if you want someone to fix a document and it's rubbish to start with, then it's going to cost way more than probably what it would have been in the first place. So the best thing you can do is always get a couple of quotes from different lawyers about how much it's going to cost, and then make an educated decision. But absolutely, tread very carefully with those sort of pro forma documents.
I'm glad you touched on that too, Jen, because this is one thing that I really appreciate when I do my legal stuff with you, is that you quote me up front, so I'm well aware of what my costs are. But what would you say to people who, you know, there's plenty of lawyers out there that won't quote. They'll just say, look, my rate is this an hour, and don't really want to quote you. And they end up going into these, you know, law firms or working with these lawyers that then just keep racking up the bill, and then they get these legal bills, and that's enough sometimes for them to be turned off legal for life. But yet they still run their businesses and they'll still make decisions in business, but they'll avoid that legal because of that. And I've heard so many nightmare stories previously. So what advice would you say? I mean, do all lawyers quote up front? Are you the unicorn?
I'm not doing it because I'm a good person. I'm doing it because that's the law.
Yeah.
Like, we have to do it. So if you're dealing with lawyers who don't provide written estimates, then they're in breach of the law. And that's the same in any state and territory. Compare the example of accountants, and this happens to me every year. They do not have the same obligations. They're regulated like lawyers, but they do not have the same regulation around having to estimate. And every year when I get my accountant's bill, I'm like, what is this number? And where did it come from? And what have you done? Like, you know, it staggers me how much they charge and how much they can charge, and they're not required to estimate. Now, the difference with us is we have to estimate, and we have to know the scope before we estimate. But what we provide is an estimate. The rules say if you're going to go beyond the estimate, you have to up your estimate. So if we ended up in a dispute with the client about our fees are assessed by what's called a taxing master, or a taxing judge, and they can decide whether we've complied with the obligations at law, and then whether we've given a fair estimate, and if we exceeded our estimate, did we provide another one? So they are only estimates, and we do our best to charge according to the scope. But sometimes things happen, you know, and you've got to deal with it. You can't ignore it, and then you have to up your estimate. But it is the law around Australia that lawyers have to provide an estimate, and they have to scope it properly. You can't just say, oh, I'm just going to run a litigation for you and it's going to cost 100 grand. You have to actually break it down into stages and scope it properly. So if someone's trying to get you to, and there's a lot of law firms that do fixed fees, obviously not for litigation, you can't, but for commercial work, like agreements and that sort of thing, you should get either a fixed fee or a pretty set estimate. So, you know, I generally say I think it's going to take 2 or 3 hours, or 4 to 6 hours, or whatever, and my rate is $4.50. So my estimate is blah. If it's something that's like a, you know, a privacy policy or whatever, I have like a fixed fee of $7.50 plus fees. So it depends, but generally it's based on how long it's going to take.
Yeah, that's good to know. So if anyone's listening and looking for legal, you are well within your right to ask for that quote.
Totally.
Up front. So that is a good tip. Jen, if you could go back to the beginning of your career and give yourself a piece of advice, or warn yourself about something, or, you know, just give yourself a heads up, what would it be and why?
Yeah, so I would say to myself, you're a lawyer, stick to doing the lawyering. In the beginning, I did my own accounts. I had an Excel spreadsheet with like 450 tabs in it. I did my own tax every year. I did my own BD, marketing, filing, admin, everything. And, you know, I'm a pretty intelligent, capable person, but really I don't know numbers, and I never have, and I'm not even going to try and pretend anymore. Going into, I got a bookkeeper, and it was like my life changed overnight. And we adapted to Xero. And again, I was like, wow, this is, you know, what the hell have I been doing? I now work with marketing and BD people because let's face it, I can read law and I can be creative in that respect, but I don't have a creative bone in my body. Let's not pretend. So my advice is let's palm out to those who know what they're doing the things that you need done. Don't try to be a, I can do it all. I mean, I did that for years. I can do it all. I can do it all. Actually, I can't. And I don't know what I'm doing, and let's not even pretend. So it seems like you don't have money at the beginning to pay for these things. But actually, if you sat down and worked out how long I spent doing those Excel spreadsheets and then turning each one into an invoice every month and then writing receipts and then doing the tax stuff, I mean, it would have been literally thousands of dollars, like tens of thousands of dollars of my billable time spent doing that sort of stuff. And now I get an accountant, a bookkeeper. It costs me $50 a month to do our books because of Xero. And I really, like, I didn't want to do it in the beginning. And now I look back and think, you were so stupid. Like, why would you even pretend to know how to deal with accounts? And really, do I care to do it? No, I don't. That whole, the bank account syncing with the Xero and all that, and the tagging of all the claims, like, I don't care to know about that. So once a month, the bookkeeper does it, and she sends me an email with any queries, like, I don't know what this is, and I answer. It takes me about 20 seconds, and it's done. I just, you know, like, take the advice. I have learnt the hard way. Don't even pretend to dabble in the things that you don't know anything about. Deal with the experts, pay them. The money, you know, the money will come back to you tenfold if you just get someone to do it. And don't be shy to do it. Like, own up to what you don't know how to do. I'm not a numbers person. I never have been. There's no point pretending. Just get
great advice.
And there are people who love it. There are people who love bookkeeping and numbers and accountants and all that. Like, just let them do it, you know?
Yeah. And they do it so much better. And it was funny. Michelle just wrote, it's so consistent. We just had Tracy Horton on, and her piece of advice was exactly the same. Outsource what you aren't great at, because, and you touched on it, there's so much value in your time, because when you liberate yourself of those mediocre tasks that you're not doing well anyway, you then have the time to focus on your business and chase those opportunities and get that, you know, invoice, or get that new client, or, you know, seek that next thing for you. So I think it's really solid advice. I think you're right. So many people touch on getting so internal about, I can't afford it. You can't afford not to do it, because the time you're wasting trying to be a social media superstar when you don't even really understand the back end of things, and you know, you're scrambling, wasting all your time when you could be focused on the stuff you're really good at and really love doing.
I had this, like, irrational, probably not irrational, probably totally rational fear that one day my Excel spreadsheet with my 350 tabs was going to become corrupted. And then what would I do? Like, I would not have gotten out of bed because I wouldn't have known, like, that would have been the end. Like, I would not have known how to fix it. And I just thought, who runs their own business on a Microsoft Excel spreadsheet that could potentially one day be corrupted? No one. Like, you can't even save that crap in the cloud. Do you know what I mean? Like, it's so risky. And I used to have that fear all the time. And now I don't even think about it. So just do it.
No, it's great advice. And Sharon just said getting a bookkeeper and changing to Xero was the best thing ever for her. Tanya just said she's held on to everything too long doing it herself, but she's putting in a place to outsource more, and it's feeling really good for her too. So, so what do you think, Jen, if I fast forwarded you to 5 to 10 years, what do you think the legal industry, I mean, you spoke about how archaic some of the courts have been. What do you think the changes will be to your industry and the law and legal in Australia in 5 to 10 years?
Well, we've always been threatened with the risk of AI taking over our jobs. So, you know, one day robots are just going to churn out shareholders agreements and we're all going to be redundant. I think there's an element of that in terms of, you know, documents being automated and that sort of thing. But I don't actually think that the personalised service that people need to address their individual circumstances will ever really change. I think what we've learned from this year is that what our jobs look like, that's going to change completely, because you know, we'll go back to trials, in-person trials, because cross-examining somebody does not have the same impact on the internet than it does in person. And the barristers who use their, you know, their frustrated theatrical drama skills in a courtroom where they slam books on the bar table and throw pens and, you know, to get their point across, that's all lost. So trials will go back to normal. We'll have, you know, in-person trials, but admin hearings like we do, directions hearings and case management conferences and mediations, there's every reason to believe that they won't go back to being in person, which means, I mean, at the moment, if I go to court, I charge the client for my time walking down to the court. So it's going to mean time saving, it's going to mean cost savings. The administrative burden is much easier doing things online. We've seen that this year. So I think the way we do our job is going to change. Whether we're still operating from offices in the city anymore, I don't know. I think in the beginning, people were like, I love this working from home. Like I'm going to start asking my boss if I can do my job. Like when everything goes back to normal, still do some days from home. But my team in particular is a bunch of really sociable people. And I think we had that sort of that high, and now we're really low again. And we're like, when can we get back into the office? We miss chit chat. We miss like our bachelor or bachelorette talk. We miss random banter. We just miss like running an idea about a case off of somebody. Now you have to make an appointment. You need to schedule a call. My team, if they ever call me, they cannot get me because I'm on the phone the whole time. So if they just want to run something past me, they can't do that. Whereas in the office, they can, you know, see when I'm off the phone and come by for a chat. All of that has been lost. And we are desperate, all of us, to get back to the office. So people are talking about, you know, the office is going to become, the city is going to become a wasteland and all these offices will be empty and rents will go through the floor. I'm not entirely convinced that's going to be the case. I think there'll be more flexibility in the law and in other jobs in terms of people's, well, my team already work flexibly anyway, so that won't change for them. But I don't think it's going to be that bad. I actually think that we're still going to maintain an office and we'll still meet with clients in person and we'll still have a team. And, you know, we'll attend court more frequently online, perhaps. But I don't know that it's going to change that much. And in terms of, you know, ultimate redundancy because of robots, I feel like if that does happen in the future, it's probably beyond my time. So I'm not going to care about it because I'll be dead. But I don't feel like it's coming anytime soon, really.
I hope they do a version on you, Jen. I hope you can get a Jennifer Holdstock 2.0 robot. I'd get that one.
It's always got a different colour nails. Yes, I don't think it's a genuine risk.
Yeah. So I'd love people, I guess, that are only just sort of meeting you now. How can people connect? I mean, I'll pop your links and everything up in the group, but do you have any, are there any resources or anything that you use yourself or that you can recommend to the people in the group that they could look at to get, I know you run some sessions yourself, so feel free to plug that. I think they're great sessions.
So we put articles up pretty frequently on our website about changes to the law. This year they've been thick and fast because literally we've had whiplash about all the changes that have happened. But we put them up regularly. We then share them on LinkedIn. We have regular Zoom sessions on different topics. So we've had 2 in recent months. We've got one coming up next week, which is about changes to the Corporations Act. So they're free. You just have to register online. We advertise them on our website and on LinkedIn. You just have to click on this link to register. And then we send you a Zoom link. But yeah, we're doing free online sessions. Next week's one is with an insolvency practitioner because there's all these changes to the Corporations Act to allow companies to try to trade through insolvency rather than jumping straight to insolvency. So, and that's relevant for people who are chasing debts from companies with statutory demands. So I think if anything this year has been, we're exhausted as lawyers trying to keep up with the changes and then trying to advise people in a vacuum when, you know, press conferences are on, they announce changes to the law and then clients ring up and say, how does this affect me? And I'm like, I'm still watching the press conference, like just give me, wait. It's been exhausting. So yeah, by all means, read the articles, read the updates on LinkedIn, read the articles on the website, reach out, but also just come to the sessions. Even if they sound like they're not useful to you, there's going to be something in there that is useful to you. And the way the law is changing at the moment, if you can get any advice for free that helps you understand what's going on at the moment, I mean, you'd be stupid not to take it. That's my view.
Absolutely. Like you said, with the changes happening so thick and fast, people think they know one thing, you think you're trading along in your business and you're doing okay, and then bam, even the data share law that changed, you know, changed how we could run, you know, data collection and sharing of data. Like it's changing so quick that you really, as a business owner, need to stay on it just to make sure you don't get caught out by taking your finger off the pulse. So
absolutely. And also, you know, the lawyers, it's their jobs to keep across things. So follow a few websites for law firms on LinkedIn, and you'll see all the updates that are there. You might then need to get specific advice for your individual circumstances, but at least you're aware of what changes are happening.
Yeah, that's great advice. Does anyone have a question while I have Jen? She cannot give specific business advice, but if you have a general question about something, feel free if you want to unmute yourself and jump on.
I'm happy to ask a question. I'm always the first one to ask a question.
Go for it.
Jennifer, thank you so much for that fantastic information. That was very, very helpful. I have a question to you about patenting. You have a brand new product and you patent. I was told by 50% of the population talked to, sorry, my phone's falling over, that patents weren't worth the paper they're written on. And if you have an Australian patent, for example, and then someone in Russia makes a nail frog or whatever, copying my product and then changing it 10%, you've got no grounds to stand on. And I would have been better off using that money for marketing, say. Then the other people say, you need a patent, you'd be crazy not to get one. And then also on the other side, if I do have a patent, I'm not about to fly over to Russia to sit in a Russian court to fight these people about their nail frogs. So what's your take on patenting?
So there's several different areas of IP that we're talking about. Patent only applies if you have a original design, and a design like that is not already in the marketplace. If you do have an original design and you want to protect it, you can protect it here and elsewhere, and it's definitely worth the money. Same with trademarks. If you have a trademark, whether it's a word or a logo or a phrase, like several words, and you want to protect it, absolutely. I litigate these matters all the time, and your circumstances are so much better if you've got trademark or patent protection. Now, it's a lot of money, and there's no point telling me that it's not. It's a lot of money up front. And so if you're starting out as a brand, you think, look, this isn't my priority. But you're going to protect yourself both here and overseas much better if you have all those protections in place. I can refer people on to a guy who does that sort of stuff, and he's very he's not cheap, but also he talks the law in that area like no one I've ever known. He talks about all the classes that you need to be registered in. He knows the stuff off the top of his head. I guess the bit about being copied in sorry, you're on mute. I can't hear you at the moment. Sorry.
That was silly of me. I'm so sorry. I do have a patent and I do have trademarking in my select classes, but I'm just wondering if someone in Russia or
so I was just about to address that point. The real risk you run, I think at the moment, I don't know about Russia, but certainly in China, is particularly if you have products manufactured in China, you know, then what happens if your manufacturer just leaks, you know, and this happens. People see their products all the time on Alibaba and Amazon and that sort of thing. What can you do about that? Yeah, the answer is not much. If you have trademark protection in China, you can do something about it. But these companies that rip people off and copy them pop up, disappear all the time. If you make your drawings or whatever, designs or whatever available to other people, and then someone in China runs off with it, what can I do for you? Not a great deal. You're right. I'm not going to be litigating in China because, one, we're not going to get anywhere and the costs are totally disproportionate. But you put yourself in a better position in China or Russia or anywhere if you have that protection. So, you know, that's right. If someone runs off with you, I had this case recently where a client's product popped up on Amazon. And it wasn't, I mean, you know, they just holus bolus copied her product. So I had to fight with Amazon, and they are not an easy outfit to communicate with. It was a nightmare, but we shut them down. The product is gone. And it was some no-name product from producer from China who probably will pop up next week doing the same thing under a different name. You know, we're in a world where those boundaries no longer exist. To keep the pace with which people are doing that sort of thing, you can't keep up with. It is a nightmare, but there are options. I mean, that her product copy is now not available on Amazon anywhere in the world because we took action against Amazon. So, you know, there are ways to deal with it, but I'm not going to pretend that it's easy. You you know, we're a world without boundaries these days, and things fall into the wrong hands, and you know, it happens. It's very hard. Copyright is a completely different issue. Sometimes you have rights there, sometimes you don't. But if you can have any sort of brand protection, and Scott will tell you that if you've got an idea and you think it's really great, but actually it's widely available in the market already and it's not capable of being protected, he'll tell you that. I can't help you. You've got nothing capable of being protected. He's not going to take your money for nothing. But if you have protection or you want to get protection and you think it's worthwhile, I absolutely suggest that you do it, because it makes my job as a litigator so much easier. The number of people who come to me with a complaint and I say, do you have any trademark protection? And they say no. And I say, what do you want? Like, I can't help. What do you want me to do for you? I can't help you. So it's definitely worth it.
Yeah, that's great advice. Julia's like, yep, thumbs up.
Any other question?
Does anyone else have a question for Jen while I've got her here? Just checking. They all get very shy, Jen. Well, I have a question for you. Feel free to jump on if you've got a question. But I'd love to know, Jennifer, if you, I mean, looking at the way that things are now for small business owners, you know, there's a lot of access to things like, Sharon just said she wants to say you're awesome.
Thank you, Sharon.
Sharon actually took on a copycat, and Jen was the lawyer that helped that copycat disappear. So you may have seen that article or those several articles that Sharon's brand Mondo Kids featured in. So Jennifer Holdstock was the reason that all stopped. So, but yeah, I'd love to know, given that we've got the situation that we've got, we do have access to a little bit of grant money and things. Where should a business start? When, I mean, you might have business owners that are sitting there today going, oh my God, I don't think I've got a privacy policy. I don't even think I've got terms and conditions. And that may be really overwhelming when you sit there and start to think, when you try and add up in your head where you've got to go, how are you going to fund all of that? Is there sort of a starting point that they could start at, you know, a consultation with a lawyer or getting some advice about where they currently sit?
Yeah, so I think the first thing you should always do is get your structure in order. So you're either going to be a sole trader or you're going to be a company or a partnership or whatever. Get that set up correctly from the beginning, get the appropriate documents in place, and then you're sweet to proceed. I think before you decide what you really need, you need to work out probably how you get your clientele and what the risk is of them not paying. So it doesn't matter what you do, but you need to work out how you get that work. Like, let me give you an example. I get work through word of mouth. The number of people that have contacted me about getting my website fixed. So I have SEO and, you know, Google AdWords and whatever. And I know that no one's going to Google Jennifer lawyer litigation in Melbourne and find me. That's not how I get my work. So there's no value for me in having that sort of stuff done. I've got a website where people can check my bona fides because someone gives them a name and then they want to make sure I'm real. They look at my website, they get my contact details, and then they contact me. That's it. People don't browse my website for hours. It's not worth it. And people don't find me through Google by doing a search. So work out where you get your clients from to work out what you need to have in place. And then in terms of whether you need terms and conditions or whatever, you work out what the risk is that people aren't going to pay. If you've got a service that you offer where people pay up front, don't worry about it. You're not going to do any work for them before they pay, so there's no risk there. If there's any delay in what you do where there's a risk you're not going to get paid, then yes, you need terms and conditions. Otherwise, you don't really have a legal leg to stand on. In terms of privacy policy, you need to have one. So that's it. Like, there's no grey around that. If you have a website, you need a privacy policy. Everybody's captured. That's it. There's no grey. So everybody, you'll need to have one, particularly if you're collecting anyone's data. So I think two things: look at what you're offering and what you need, and then look at the risk in terms of not being paid, because that's the main risk, isn't it? You're not going to get paid. Take Sharon's business though. If I order something online from her, I have to pay when I order it. She's not going to send it to me if I haven't paid. The only risk really probably she would have is if I want to return it, and how do I get my money back? That's where she might need terms and conditions. But otherwise, you pay up front and then you get your product. There's not really a delay. Whereas in my service, we have a 7-day, we issue an invoice at the end of the month, and then people have 7 days to pay. There's every chance I'm not going to get paid. So I need terms and conditions in there to protect me.
Yeah, it's risky business when you do service up front, isn't it? But a lot of people in that service industry do work like that. They provide the service and then they sort of chase the money afterwards.
Yep.
Yeah. And is there a risk then, Jen, with the insolvency law that's changed where businesses, I've seen this pop up in groups where businesses are sort of allowed to, where they weren't allowed to now, run insolvent. For those that don't know, means that they can't afford to pay their current debt. So they're sort of running really behind and really shouldn't be running their businesses, have been given a grace period now where they're allowed to do that. So is there a risk then to, when you're doing business in, the next 6 months? I know I've been approached by some businesses to do work for not consignment, but upfront. Is there a risk now to that, doing business with somebody you don't know, because they could be running insolvent and you don't actually know now?
Yes, absolutely. Yeah. If you're providing services, you either, I mean, I don't do this, but you'd either get paid a significant deposit or have very strict trading terms. But if people aren't paying their debts as and when they fall due, under the legislation, they're deemed, I guess, to be insolvent. And they are getting grace periods at the moment, and that's extending out to next year now. And the new laws are going to allow people to try to trade through insolvency, whereas that was never the case. It's an American model and it's brand new, and somebody will be appointed to your company, like it used to be an administrator, but an administrator would stand in your shoes and you then became powerless in your business. In the new model, you still run your business, but you have someone assigned to you that helps you try to trade through. That is brand new, but what it does mean is that a lot of companies, this is harsh and I'm sorry to say it, but a lot of companies are going to be delaying the inevitable. And when that period is over, they're going to start falling over. Because if you can't pay your debts now and things are going to get financially worse, it's just going to get worse. So you're going to have bigger debts. It's
quite scary, isn't it?
It is. But if people can pick up, like take retail, not retail, hospitality, if they pick up in a week or two in Melbourne and they have a huge summer, they might be able to recover some. But in a lease situation, I've arrangements for people where they get a 50% waiver of the rent and then a 50% deferral. When they recover, they have to make what they would have already made and paid under the lease plus the deferred amount. And they're trying to rebuild their businesses. It's going to be very hard for a lot of people.
Yeah, we're not out of the thick of it yet, are we?
No way. I don't even think the real pain has started. And JobKeeper has seen so many people through, and that's just starting to end now. I know lots of people who got it all year and now they're not getting it. And that is going to start to bring a lot of people to the insolvency table, I'm afraid.
So is there anything you can ask of if you had a client or someone that came to your business that wanted to do business with you, is there something that you can ask where you can gauge whether or not they can pay?
You can ask them for a letter of comfort from their accountant.
Okay.
That they are, that you don't get to see any of their financials.
No, yeah.
But you get a letter from their accountant saying that they're currently trading well and there should be no risk due in dealing with them. It's quite a confronting thing to ask for, so tread very carefully. The preference would be you get some sort of deposit or upfront payment and then you have tight trading terms. My attitude really is I don't act for people if they're not paying me. So if they don't pay me within my payment terms or we haven't agreed any other arrangement, I don't keep acting for them because I'm not a bank. If they need a loan, they can go to a bank. Yeah. So, do the same thing. But if you've got genuine concerns, like I had a litigation years ago against a company, they brought the proceeding against my client. I looked them up on ASIC and there was a strike-off action in process by ASIC to have the company deregistered. And I said, sorry, you're the plaintiff, you're suing us, you might have to pay our costs, you better pay some money up front or we're not dealing with this litigation. I said to the court, I can't trust this plaintiff. They're being struck off by ASIC at the moment. So, yeah, and also do searches on ASIC, they're free.
Yeah,
to find
great
out if
point.
company is registered or not, because if they're not, don't even deal with them.
Yeah, great advice. Thank you so much, Jen. Does anyone else have another question before I let this fabulous woman go back to doing what she does best? No, you're all totally engaged and loved it.
I hope they're not terrified into sort of submission. I hope they're not like, oh my God, what?
No, I think they're all just like, yep, it's all good. So thank you so much again for your time. Been an enlightening chat. There you go. So they're not asleep. Some of them I know are doing other things while they're listening in.
Yeah,
so
sure.
But thank you so much again. And Jen, thank you for being a judge this year. So I haven't told anybody who's judged what categories, but really appreciate your time, your insight, your feedback. And the last question I've been asking the judges is just, you know, you obviously see all the applications that come your way. You see all the effort that people put in. Everybody's got a different business and a different way of doing things. I'm about to hit live this week on the top 5 for each of the categories, but would you have some advice for those that don't make the top 5? What would be your advice to them as a judge, seeing the caliber that we've had this year?
I'm going to be a little bit harsh. Is that okay?
Be as harsh as you like, and because this is really what it's about. I really want people to take away and go, okay, right, game on.
Give your submission to someone else before you submit it and get them to proofread it.
Yeah, great advice. Because we've had some judges that came back and said there were spelling mistakes through some of the submissions. There's been grammatical stuff.
Yeah, and you know, I've treated the reviews a bit like I do when I get a CV. Like if someone is applying for a job for me, where you know we've got to get things right, and they've got spelling mistakes and typos in their CV, you know.
Yeah, you can have. You can technically have
that. I don't look upon that favourably, really. But that's just one thing I would say. I guess the other thing I would say is, and this is, I didn't expect to find this, but someone has put in like a 30-page submission and it's fantastic. And somebody has put in a 4-page submission and it's fantastic. And I actually learnt more about one person from their 4-page submission than I did from the 30-page submission. I got to the end of the 30-page submission and I was like, I feel like I'm still not clear on what this person does.
Yeah, so be really clear in your communication.
Yeah, absolutely. If you can done out in 4 dot points, this is who I am, these are my qualifications or experience, this is what I'm offering, and this is why I'm different or whatever. This is what one of them did. You know, it was 4 pages, but I got everything I needed from that submission, and it was really good. Now, it's not about being time poor, because I read the 30-page other one, but I got to the end and thought, wait, hang on, I have to go back and still not clear on what they're offering. And I think for a judge, you know, we were all full-time employed and we're time poor, we've got other things. You need to capture our attention pretty quickly. And another one, which I thought was great, gave examples of what they'd done. So it's very easy for me to say, I run litigation, I run disputes, and people might be thinking, what does that look like? I don't really know what that looks like. Whereas somebody put in one of their submissions, these are some examples of the type of work I've done. And they were only, like each one was only 4 or 5 lines, but I did this here, I did this here, and I did this here. And it really made me understand quickly what their service offering is and how they were able to help this client. And so it made me understand a lot easier what they do. And so for me, it might be like, I acted for blah, 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 in a case in the Supreme Court of Victoria, and the issues were blah, 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 and we had a win because of blah, 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 blah. Now, obviously, there's confidentiality around that, but you don't have to mention the parties' names. You can say, I acted for a trucking magnate in a copyright case in a federal court. It lasted 5 years and we won. That gives you some idea of the nature of the type of work I do. So I just think, yeah, have an attention to detail, get someone to proofread. And I can't proofread my own work. Right?
No, because you read it through your head, don't you?
And also you've drafted it, so you don't have the same. So I always give my work to a member of my team. Say, can you just proof this? I can't proof my own work. So when I say that, I do mean give it to someone else. Get someone to check it. Make sure you get to the point of what you're trying to say, and you don't need to have 30 pages if you can say what you want to say in 4 pages. But also, we want to know what it is you do. That needs to be pretty clear.
Love it. So I hope everyone takes that on board. So and thinks.
Sorry if that sounded harsh, but
no, it's great. I think it's a good lesson, because sometimes I talked about it before. Sometimes we rattle on about stuff and people just sort of glaze over, where you could be really clear, and communication is a skill you can actively work on every day in your business. So,
but also, I mean, I forget, like I've been litigating for 18 years. I use language that I think everybody knows. Sometimes you need to be reminded that people don't know what you're talking about. So people need to say, I'm sorry, you've just said discovery, and that sounds like something that happens in a, you know, in outer space, in a you know,
Moon
with an
landing.
astronaut. What are you talking, you know, like, I don't understand what that means. And I'll say, oh, discovery, oh, I'm sure. The process by which you show each other the relevant documents in a dispute. You know, so you might know in your submission what you think you're talking about, and you might know what you do, and you might think it's obvious, but it might not be obvious for someone who's looking at cold.
You're amazing, Jen. Thank you so much again for your time, for being a judge, for answering the questions. Super appreciate it. I'll post up all your details so people can connect and follow along with you. But have a fabulous day, and I'm super pumped. So
yes, nice to meet everybody.
Yeah, thanks so much. Everyone's saying thank you. Yeah, thank you. Thanks, Jen.
No worries. Take care, everyone. Stay safe.
Bye.
Bye.